I'm just going to give it another 30 seconds to allow people to join before I start. We will be starting promptly. Well, thank you everyone for joining us for the second of our 4 sessions on fighting racial injustice for children in the criminal justice system. For those who joined the last session, you know that we had some of the leading voices from across the world speaking on issues of race, children and criminal justice. We learned about unconscious bias, adultification and the special status that children have in the criminal justice system. Today, as last week, we have an extraordinary lineup of speakers that I'm excited to learn from and look forward to them sharing their wisdom and experiences with you. I am Ika Stevenson. I'm the co-founder of Just for Kids Law, which I set up with Shawnee Lamb 16 years ago. Since those early days, we've been providing specialist representation to children in the criminal justice system. I'm now the legal director of Just for Kids Law and oversee a legal team that covers many areas of law. Unfortunately, we see discrimination in each of those areas. The only thing that has changed is that now it seems funders and some institutions are keen to see, identify and change this racial injustice. For example, in 2014, Just for Kids Law intervened in a case about the strip search of children in police stations. We declared then that it was a sexual assault, but few people heard us. Recently, we've seen a strong public and institutional response to Child Q, who is also assisted by Just for Kids Law alongside Bat Murphy solicitors. We will hear from Shamik from Bat Murphy a little later. And just yesterday, we saw another example of a child being strip searched at the police station who felt suicidal afterwards. So while the issues are getting greater attention, the actions and the state response seem to be getting worse. In 1999, the McPherson report identified additional racism within the police. However, in 2021, this Conservative government-backed report said institutional racism no longer exists in the UK. This regressive thinking is seen across many legal areas, criminal justice and immigration being the most easily identifiable. While in the US, as a response to Black Lives Matter, there's been a widespread removal of Confederate statues. Here in the UK, the Conservative government want to introduce legislation so that those taking down statues can face up to 10 years in prison. Despite a regressive government, we are seeing pockets of progress and innovation, and we want to share those with you. We're grateful to the Barrow Cadbury Trust who have funded this work to improve criminal representation for Black, Brown and racialised children. We are extremely grateful that this funding has enabled us to bring to you some of the leading experts with exciting ideas and an opportunity to create what we think are incredibly powerful tools for criminal practitioners to fight racial injustice in the legal system. As I mentioned at the last training, the themes for these 4 sessions were identified by Just for Kids Law's clients. The issues we are asking practitioners to challenge are based upon the problems that young people themselves identified as exacerbating race in the criminal justice system. We are, as always, grateful to the young people who shared their experiences and ideas and feel privileged to work with them and to amplify their voices in bringing about changes to the system. We have specifically excluded stop and search in our tools. We're fully aware that this is the first and most frequent form of racist contact that children have with the police, but felt that this was outside of the remit of criminal practitioners. We want to note here and in this space that former Home Secretary Theresa May recognised that stop and search was racist, while the current Home Secretary is extending police powers around stop and search. However, many Black, Brown and racialised children come into contact with the police than ever and end up in court. How we represent them at the police station can be crucial. It can affect the adults they become and the trauma they carry with them. We ask practitioners to reflect on this part of the criminal justice system and what we can do. And we are grateful to have Sandra Paul, the leading expert in children in contact with the police, helping us all to identify points of challenge. So just a couple of housekeeping issues. We want these trainings to be interactive, and please do ask our experts questions. If you put any questions in the Q&A rather than the chat, then they will come to me. We hope to develop a rich conversation in this space about these issues. The guides will also be uploaded into the chat, and if you have any questions after the event, please do not hesitate to contact YJLC. If you'd like personalised and tailored training for your staff or organisation, we would be more than happy to provide it. So first, we have Sandra Paul and Matthew Hardcastle. Sandra Paul is a partner at the law firm Kingsley Napley and a member of the Youth Justice Legal Centre Advisory Board. Sandra was also on the advisory board for creating these Fighting Racial Justice Toolkits. Sandra chaired Justice's group Tackling Racial Injustice and is particularly experienced with navigating children and young adults safely through the youth justice system, and has recently written LAG's updated Defending Suspects at the Police Station and Police Station Advisors Handbook. Matthew is a specialist in pre-charge investigations and litigation. Before joining Kingsley Napley, Matthew was a duty solicitor at a busy East End firm. I'm confident that they are the very best people to train on the subject of raising children in the police station. And I will leave it to the experts.
Thank you, Aika. So Matt is actually the person who authors the Police Station Advisors Handbook, but those two texts together are really helpful and I think essential support to those of us who are going to the police station. The reason why it's important, I know it's really obvious, and it was really important to hear you in that introduction, Aika, but the role of the Police Station Advisor is becoming increasingly challenging for representing all children, but it's even more so when we come to Black, Brown and racialised children. Our role is to safeguard and protect their rights and act in their best interests. And we, as police station advisors, are all that there is between the police and this child, and it's necessary for us to inspire confidence and skills in our abilities, understanding that if we don't stand up for them at the police station, there's nobody else to do that for them. We heard really clearly when we were doing the piece of work for justice that children sometimes do not trust their solicitors, particularly when that solicitor is the duty solicitor. And that's not necessarily got anything to do with ability, but it's got to do with some of the ways in which the system is structured and approached. And so what we're trying to do in this very brief presentation is just highlight some things which might be important to think about at the police station. We understood that there were going to be a mix of people here in terms of levels of exposure to attendance at the police station. And so we've kept it, I hope, at a level that keeps everybody interested. And we have also thought about a loose scenario just to guide us through some parts of the areas that we want to discuss. And so I guess if we go to the next slide, we come to our very first top tip.
Well, the tip. So there you go.
Okay, which is make a note of everything, and I can't overemphasize this. What it looks like, what it sounds like, what it smells like, how busy it is, whether you get a complete answer. Make a note of everything as you go through the police station. That note at some point is going to become relevant as you move along. So our scenario: you are on own client duty. It's 10:30 in the evening, and Omar Jackson, aged 15, is under arrest at Avonmore Police Station. You are going to call the police station, and what we're looking at here are what you are trying to achieve when you get to that phone call. Essentially obtaining as much information as possible and understanding and assessing the extent of any vulnerability. I should have said that what you will receive at some point after today is quite a full pack. We're not going to go through all of the information here, but Matt and I, in pulling this together, have tried to include all the references that are relevant to the information that we're speaking about. But that is what you were trying to do with that first phone call. And if you look at the next slide, you'll see that there is a checklist which is available in Defending Suspects at the Police Station. LAG have kindly allowed us to reproduce this and some other checklists, so you don't have to buy the whole book, which are really helpful at identifying what you're needing to obtain, what you need to ask, what the aim of this conversation is.
So for the purpose of our talk this evening, we're going to be going through this information from the custody side. So Omar is 15 years old. He's been arrested on suspicion of robbery, being concerned in the supply of drugs, Class B, and assault on an emergency worker. He's spoken to by the police, who had seen him in the area several times during the day. He appeared out of place and wary as the police approached. On speaking with him, officers smelled cannabis. He was stopped and searched under Section 23 of the Misuse of Drugs Act and PACE Part 1. While speaking to the police, he became abusive and obstructive. He was arrested. The police have undertaken a Section 18 search of his home address. No items were recovered. A strip search was authorised. A small amount of cannabis was found inside the waistband of his underwear. His mum is at work, so an AA from the scheme is on their way. Police are ready for interview, but there have been significant delays in getting him to and booking him into the police station. If they don't get started soon, the interview will have to be delayed until the morning after Omar's arrest period. So what we wanted to do now, and hopefully this can be opened up to you, is to get an idea of what you think we should be doing now. Which of these is the part that you have to do first, and which are the parts that you would do second? We should have a few more minutes on the poll, and then hopefully we can pull up the results. A few more moments, not a few more minutes. Okay, is it possible to see the results? Good. That's what we wanted you all to see, is speak to the client first. That has to be the absolute priority. It's also really reassuring to see that get in the car is absolutely last. All of these are things that can and should be done before there's a need to get to the police station. We'll move on from the poll. When you speak to a suspect under arrest, you will have or they have rights and entitlements. And actually that's an important distinction, that these are their rights, they're not your rights. The right for consultation and the right to have somebody informed of their arrest are rights that we see far too often getting delayed because of difficulties at the police station. This doesn't mean that they're doing the delay on purpose, but it's just simply the practicalities of getting someone to be able to speak on the phone are becoming increasingly difficult. When you speak, the phrasing that we've put on this slide is what you're trying to achieve. It's not a case of just talking at people, but it's trying to get your client to be able to understand that you are there to support them and understand that you want to know what they have to say to you. We all know that that first call is not a call where you can have any confidence that the call will be done in any way confidentially. But you need to get into the process of building that rapport. There is a child here who is going to be in an alien environment. No matter how many times they've been arrested, it's still an alien environment, and they need to understand that you are someone who has an interest in them. And that's an interest in them as a person, but also your professional interest in making sure that they are dealt with in the correct way. The reason we suggest telling them what the time is to give them an anchor, because it's too easy to lose a really good understanding of how long you have been in a police station. They are places which are disorientating. They're disorientating when you go in there as a solicitor. I think anyone here who has been in a police station professionally will have that experience of just at some point not really being able to put a firm view on how long they've been there. And that just helps give them an idea about what time it is, so that when you say, this is when I think I'm going to get there, they've got a better context to be able to manage that. When you're giving them the advice that they shouldn't be talking to the police until you arrive, with children especially, it's helpful to give them a bit more detail. It's helpful to allow them to know the bits that it's okay for them to deal with. So it's okay for them to be asking for something to drink. And if an officer asks whether they want that, that's a conversation they can have. And it just helps, I would hope, settle them. So the next part of the information is our client sounds distressed on the phone. He says the officers bent his arms back while he was on the floor. He'd had surgery in his shoulder 2 months ago for a rugby injury. And he still has a cut inside his mouth from his face being on the floor, and it is bleeding. It's the 8th time the police have stopped him in the last 8 months. He's had enough of the police harassing him. His mum is at work, his 20-year-old sister is at home, and his uncle and cousin live next door. He would like his mum to come to the station, but she does not finish work until 7 a.m. and he is due to attend an interview for a new school in the morning. When you're looking to make representations to de-arrest, it is worth remembering powers that the police have to exercise to be able to effect a lawful arrest. A lawful arrest requires 6 questions, 3 subjective and 3 objective. Did the arresting officer suspect that an offence had been committed? Assuming the officer has that suspicion, did the arresting officer have reasonable grounds for that suspicion? And did the officer suspect that the person who he was arresting was guilty of the offence? Assuming the officer had that necessary suspicion, did the officer have reasonable grounds for that suspicion? Did the arresting officer believe that for any of the reasons mentioned in subsection 24.5 PACE, it was necessary to arrest the person in question? Assuming the officer had the necessary belief, were there reasonable grounds for this? You'll see there we've used a colour-coded explanation to be able to separate out the subjective parts and the objective parts of those questions. If the answers to those questions are in the affirmative, then the officer has a discretion which allows him to make an arrest in relation to, that allows him to make an arrest. Code G is one of the most important codes, certainly when you're dealing with arrest. Power of arrest is only exercisable if the constable has reasonable grounds for belief that it is necessary to arrest the person. Officers being shown Code G will realistically need to be able to find a way to describe why their arrest is compliant with the code. And many of them will not have thought about it in that level of granularity. Too often there is just the thought, right, we'll arrest, we'll take it there. And it's sometimes just helpful just to pause, just to look back, take the officer back to first principles, take them through it and see whether the grounds for arrest are still made out. The necessity criteria is a wholly operational decision, and it's got that split between the subjective part of it, the officer's view, and the objective part of it. The arrests are often made for the prompt and effective investigation of the offence, and it's worth remembering that it has to be prompt and effective, because again, too often an arrest just becomes a crux for dealing with an initial part of it, and necessity is a higher bar test. One of the reasons why an arrest may be necessary is if it is to give rise to a special warning. And if that is one of the grounds relied upon by the police, take a moment to think whether in fact this is a special warning case. Other reasons: interference with the investigation, evidential samples, or for indictable offences, the need to enter and search without warrants. In assessing the objective grounds, the officers, including the custody sergeant, should take into account not just known facts and information relevant to the likelihood that the offence has been committed and that your client committed it, but also information that points away from either point. Remember as well that there are two assessments. The officer will arrest on the street, but the custody sergeant also has to authorise detention as well. And so the custody sergeant can sometimes be a better venue for these arguments. They're less directly involved with the immediate instance before the arrest, and they will be able to look at it with a slight detachment that the arresting officer may not have at that point. Code C's paragraph 3.4b and note for guidance 3ZA, along with Code C 3.25, are really important because these contain the rights to information, and they include the information that is essential to challenging the lawfulness of the arrest. So if you're dealing with a case where you think that the arrest is not there, then these are the routes to try and get further information, and just to really focus everyone's mind as you're dealing with this. Okay, we're now going to start our second poll.
So what we're presuming also is that the representations that you might have made, remember one of those options was to make representations right at the beginning in that phone call, or after you speak to your client. One of the things that you might have done is made some further representations. Presume that they weren't successful for the purposes of this. We've got a poll on here. I'm mindful of the time, so I would say if you've just got 30 seconds to do it, then let's do it. Which ones do you pack? And I guess you could add to that list Matt's other book, but you could. Good one. It's really small. Let's see. Lily, let's see where we've got to so far, just because I'm mindful of the time, please. Excellent. So that's all the right direction. We're obviously preaching to the converted already here. And I think that really important, given the facts that we've got, is the ability to take photographs. Obviously, you need the legislation, etc. But it's those little bits and wipes. I know it's you know, for this cohort of children might be particularly important, and how, in terms of how they feel by the time you arrive and their ability to deal with you. Okay, all right. So the next slide then, please. I guess we can miss this one out altogether, but just to remember, before you leave, there are a couple of things that you might be able to do to help this situation. And Matt, we've highlighted them on the next one, and they included, is there anything else that you know about this child? Is there anything else that you might be able to find out about this child? Remember at the beginning, it was an own client. Does anybody else know him? Has anybody else dealt with him? Who's his regular solicitor? If this is somebody who has been to the police station before, we've already known that there are these stops and searches in the past. Did they result in anything? Which officers dealt with that? Is there a particular issue going on here? And of course, is there somebody else that can act as appropriate adult, given that mum's not going to be around, and you're balancing those competing aims in terms of getting this child out of the police station, or at least the process started to get him out of the police station as quickly as possible, versus having you know, somebody they know. Sometimes that's good, sometimes not so good. We have to make that assessment, but somebody from this scheme may well not be most appropriate. So moving on, en route to the police station, we understand that uncle's going to be there. He can be there from about 12:30, remembering about the time and this child being at the police station. On arrival at the police station, please inspect the full custody record. That means the full custody record. They will always shove the front sheet at you. That is not good enough for you, for any child, I think, but it certainly isn't appropriate well, it's not appropriate for anybody, but for children in particular. And that includes the FME notes, any other health notes, property records. Sometimes the police get a little bit dodgy, like, well, you know, that's his private data. Well, I'm sure he's happier for me to have it than for you to have it. So we've put there the reference that enables you to say to them really clearly that I need the whole thing. And you can see and probably know the things that we're looking for. In particular, I think, reasons for the arrest, to see if they can be challenged, because we're still looking for an opportunity with this child to avoid him being interviewed at what is now 11:30 at night. And again, making sure that you've got all the information that you need with which to make any challenge, understanding what the evidence is, the use of force, the biographical information that they've recorded. Is it correct? Is it relevant to the facts of the case? The searches that the police have taken on board to do, are they relevant? Are they lawful? Is there anything there which causes a problem and might have an impact, if not in terms of further challenging the arrest, because you're going to do that when you get to the police station as well, or in terms of information that may become relevant later on in the process. The levels of supervision that have been applied during detention, you know, that 30 minutes, that check, particularly that's done with children, on one hand, really important safeguard in terms of their health and welfare. Just thinking about it from that child's point of view, someone's coming every 30 minutes. It helps you understand what the experience for them might have been like previous to your arrival. Moving on then, we have included a checklist 3 from defending suspects, which again takes you through what might be important at the police station. And you can look at that at your leisure. We've given you just some further information here in terms of what you might have received as written disclosure. Matt, is this still me?
Yeah.
Great, okay, I'll carry on. I didn't want to hog your space. Just some further information, and we could take the time to read it all, but essentially it gives more information. Let me just do that briefly. I'm just mindful of the time. It says on Sunday, 16th May, 7:20 hours, so in the morning, client was seen on foot with known gang members on Bonhill Road. At approximately 18:30, he was seen again on an electronic scooter travelling east along Worship Street, approximately 19:20. So, you know, police officers were in the vicinity making inquiries concerning the report of a theft of a scooter that had taken place earlier that day in the same area, stopped our client because they smelt cannabis. On being questioned, client was initially cooperative, showed the officers a provisional driving licence and then became obstructive, resisted the search, arrested for assaulting an emergency worker. Let's see what else is important. We've left the references there for the bits that are relevant and that should pique your interest if you're getting this as disclosure. Complainant in respect to the robbery has provided a description of the assailant which matches your client. You can see all the hooks here and little crumbs in terms of further information that you might ask for. CCTV in respect to the robbery is currently not available. Made admissions at the scene and recorded and body-worn video of being in possession of cannabis. Small amount of herbal cannabis found inside the waistband of his underwear following a strip search at the police station. The interviewing officer will endeavour to play the body-worn video in the interview, though technological reasons might prevent this. These are all kind of, there are a whole bunch of things here which I'm sure are already firing off things in your own minds about what's problematic here. And if you go on to the next page, you'll see what we're wanting here is further information, and Matt made reference to it earlier on. But in addition to that normal disclosure, there are avenues for you saying, I need further information in order to be able to advise my client. And those are the things that we should be looking for and asking for in the police station. The police officer is saying to you that they can't, we're not sure if the body-worn footage is going to work in the interview room. We'll find another way to do it. There are other places in the police station that they can at least show you the information that they're relying on. You are entitled to that information. I think it's one of the places where we get worn down most in the police station, but it is really important for all children and this cohort in particular, given what we've heard already from Omar about the circumstances of his arrest. Now, the police are going to decide what is sufficient or not sufficient, and that goes back to the very first point, which is record everything. Now, I'm not suggesting that, on every occasion you're going to do the whole bullshit thing about getting the police to, you ask them the question, get them to sign that they've refused to answer the question. But there are degrees between that and going, oh, look, I'm just going to leave it. We shouldn't be leaving these pieces of information unasked for in the police station. Done that. One of the other things, and it's another route to challenge, and I think I put the wrong year on that directive. I did. So that directive that's in there, when you get the pack, we'll try and change it before you get the pack, but it's actually 2013, that directive, and it's an additional way of getting information. So the police have to provide you with sufficient information. If they have information which is relevant, they should be sharing that with you, and you should be able to ask for that information in order to do any of these things that we've got here. That's valid information. Police are saying they can't give it to you, they won't give it to you. Ask to speak to the inspector if you think it's a piece of information which is absolutely relevant to your advising the client about the police station. This is all about making notes, which we've talked about already. One of the questions that's sometimes missed at that stage, and it feels a bit cute to ask it because you're not sure where this is going to go, but what are the potential outcomes? And I know that we're going to hear some more about diversion later on, but that's one of the questions you should be asking, I think, at that stage in terms of disclosure and the process before you get into the details with your client.
So, at this stage, you can also then reconsider making representations to the sergeant. You can see whether the arrest has been lawful. If there are any concerns, you can make submissions that there should be a de-arrest. On the basis that that doesn't happen, when you're having the consultation with the client, there are certain things you can do to help try and build rapport. It still remains frustratingly uncertain whether legal professional privilege will apply when there is an appropriate adult present. But some clients will speak more freely without an AA being present. Some clients will really take great strength from the AA being present. And so you just need to factor all of these things in together so that you can understand what is in your client's best interests for that occasion. Because even if a client has wanted an AA present last time, it doesn't necessarily mean that they would want an AA present all the way through second time, and vice versa. And it's just trying to make sure that you understand what your client needs from that situation to be able to do their very best with you. Clients are likely to trust you more if you give them reason to trust you. If you are actually making an effort to understand them and protect their rights and listen to them, they are more likely to feel able to share things with you, especially if it's one of the first times that they've met you. Show them that you're interested. We are all involved in this area of law because we have a genuine interest, and let them see that. Let them understand why you're there. All of that helps you demonstrate these things to the clients. It's not just about what you say, but it's about letting them understand it from what you do as well. Your clear message needs to be, help me understand what has happened and help me understand you. With your client's instructions, tell them about your professional obligations, because we certainly see information that people are confused about the role of a duty solicitor. Take them through it. Let them know that your role there is to advance and protect their legal rights. Nobody else's. It's their legal rights that you are there to protect. When you're going through, explain the caution, explain the tactics the police are likely to involve in the interview. Take them through the options of answering questions, no comments, or doing a prepared statement. Help them understand who has to read the statement, whether it's you, whether it's them, what the benefits of that are. And bring them along with you so that they can make an informed choice. If you can, take them through what's going to happen in the interview, because we all have a fairly good idea about where interviews are going to go. Let them know that they've got enough going on without having that added element of uncertainty. And also remind them that they have the right to a consultation. And it's helpful to be able to explain to them not just what to do if they want to talk to you again, but how they should respond if you indicate that you would like more time to speak with them. So we'll do a very brief poll and just have it running for about 20 seconds. How many would go through the sorts of approach that's likely to go into the interview? Great. Can we see what we've got there? Perfect. And that's exactly right. Help them understand the way that the questions are likely to be phrased. Just if you can take away as many surprises or unknown things as you can, then you just help settle them, and that just helps them go through the process with you. In the interview, there's always a difficult balance between active participation and not just getting into the sorts of unhelpful arguments with the officer or point scoring. There's no benefit at all in a solicitor scoring points for the sake of that solicitor's own ego. But you cannot sit there and let an officer put your client into a difficult position when then doing it in a way that you could interject to try and stop. And think about where the questions are going. Think about whether your client is being put into a particular direction. And if the questions that are leading there are questions which you can object to, then it is worth doing that at that point. The use of language, it's something we've seen repeatedly in court. The avoidance of tag questions, the use of language that a police officer may understand or may not understand, and the children may struggle to understand, but they may well present to you as if they are following, as if they are completely on side with everything that's going on. I find it unbelievable that we've got this this level of work that stops advocates asking questions in different ways, but then you go to a police station and you can find officers asking tag question after tag question after tag question. It's worth interjecting. It's worth making sure that if the officer is going to ask a question, especially if your client is going to be answering it, it is a question that is asked in an appropriate way. So it's worth looking on the Advocates Gateway. As I said, they have, in my view, equal relevance when dealing with young people in custody. Think about the sorts of references they're using. Inappropriate references to size or strength, or when they are providing narratives. All of this sort of stuff is not really going to be getting the police officer anywhere. It's the sort of thing that can make your client feel like they're slightly uncertain about where things are or what the purpose of the question is or where things are going. When you come across a question that is improper, you need to be active in managing that, because most officers, once they've been called out on it, realise, and it can change the tone of the interview. It's worth remembering that there needs to be active participation, and it requires active critical listening. Now, we all take a note, we all have to take a careful note, but the note shouldn't be so important that you're not able to take the time to be able to critically assess questions that have been asked. And here we have some bullet points which are just setting out the sorts of occasions where an intervention may be appropriate. Even in a no comment interview, the length of the interview is now becoming a relevant factor in respect of inferences. That is even more the case when it is dealing with prepared statements. And so if you have a police officer who starts going through the list of pre-prepared questions, where they say, for example, do you drink? Do you have a drink problem? If you do have a drink problem, how much do you drink every day? If you've been drinking today, is this the same amount that you would drink every day? Because they are then starting to use time. And the approach that the Court of Appeal is now taking is that the greater amount of time that the interview is lasting may be indicative of the level of detail that it went into. So if the questions are actually extraneous and nonsense and just the sort of thing that has been printed off from a manual somewhere and is repeated in an interview, it is worth stopping that so that you protect your client if the matter goes further forward. I think this is back to you now, Sandra.
It is, thank you. And I'm mindful of the time, and you'll remember that I said you'll get all of this information, be able to go through it at your leisure. But we couldn't do this without talking a little bit about the audio and visual recording of interviews. And I'm sure many of you will already be familiar with Cody, but it's one of those parts of the police station which is open to having an impact on this cohort of children. Now, it's supposed to be designed to, as a safeguard, it says, for suspects and also for the interviewers. But I can't remember the last time where there was a video recording of the interview actually captured what the officer was doing, perhaps other than the back of their head. So the idea that it's there to protect us all, I think, is a little bit rich. But there we go. Just briefly, what do we think might be some of the downsides in a poll, Lily? I think we've just about got enough time to do it. What do you think might be some of the downsides for Black, Brown and racialised children during an interview that's being video recorded? You can just, I think, pop them in the chat, can you? Yeah. Okay. I can't see anything come up at the moment, but just going on what children tell us. Identification, great, yeah, belittled. Absolutely. Intimidated, yes. So some of the things that come up, and they're all coming through now. This is all, won't be able to see body language, yes. Absolutely right, and I think it would be good if Youth Justice Legal Centre, we could capture some of these ideas because they're all absolutely right. This idea about that kind of discomfort and being watched and surveilled kind of harks back to some of the information we've heard already. Lack of trust regarding the footage, how it's going to be used, perceived as a form of intimidation, doesn't capture the presentation of the officers, so it does what the child is doing but not what the officers are doing. One upside that came up was that it captures the child at the time when they're in the police station, as opposed to 2 or 3 years later when this actually gets to court. It captures all of these things that you're saying here are absolutely right. Demeanour, body language, all of that is open to that kind of unconscious bias when it's played again. And it can be quite alienating for AAs as well. So just moving on from there, Matt, I think it's just worth, we can move forward as well, thinking about what that looks and feels like and asking the police to help you understand why it is that they're video recording. Interestingly enough, when you look at the codes, it says that they should video record whenever the person is vulnerable, and children are said to be vulnerable. So it's amazing that they don't do it more often in many ways, but I'm quite glad that they don't. Despite the reason, I mean, there's some more information in there, but I'm mindful of the time, and I know that we wanted to leave some time for people to ask questions. Should we move on? to talk a little bit more about ID parades. We can come back to some of that in the questions if there is enough time. You've done your interview and the police officer's given you a description of the person. We just wanted an excuse to talk about Code D and Annex A in terms of identification procedures. And so sometimes you get these very loose, don't you, descriptions, particularly for Black, brown and racialised children. And actually this one's quite interesting because it does say very dark skin, which often you don't get that ability to identify really what they're talking about. We've given you some information here to remind you regarding eyewitness identification, the procedure, when they should be held. The selection is a really important pinch point for this cohort of children. Really important that if the police are doing this, or when the police are talking about identification procedures, or if you suspect that they might be thinking about that, that you take that opportunity to make sure that they are applying the law in terms of the procedure that they select. And if it is going to be a video identification parade, that you use the provisions in Code D at 3.7. We're looking at images that resemble the suspect, and you're being mindful, aren't you, regarding age? And of course, it may be necessary, you know, when they plug it in and they put in what your client's age is, it's what your client looks like, not what his birth certificate says. Making sure that height, skin tone in particular, don't be shy about saying it. And I have people who I speak to, and they're like, well, you know, I'm not sure if I should say. Yes, say, you know, if the skin tone is not right on the other images, you need to raise that. Hairstyle, scars, tattoos, build, position in life, you know, encourage and demand where you need to, that they amend those images, either amend all the images by redaction or pixelation, whatever you think is necessary to make sure you've got people who resemble your client on the ID procedure. Next slide, please. We've included one of the checklists again from defending suspects, which might give you a better view than the one I've just given you regarding all the things that are necessary.
Great. I think we are coming close to the end, and to make sure the time to answer any questions. While we're going through these last few slides, if anybody has any questions, could they please put them into the chat, and then we'll try and end or at least the presentation part in the next few minutes, so that we can cover off any questions that come. So presume that you've attended the video ID procedure, client has not been identified, you're back at the police station and have updated your client regarding the outcome of the ID procedure. So post-interview issues. What's the officer's view of the evidence? Are we pushing for an NFA? Is this a case which needs a diversion, or is it cautionable? It's going straight to the CPS. Ensure that you can understand why, and the reasons are not based on your client's race, for example, location of family home, family structure, need or presumed associations. When looking at objections to bail conditions, the NPCC operational guidance explains proportionality as being limited to the minimum of what is required to achieve a legitimate policing purpose. The police will often overlook this operational guidance. How often do you see bail conditions that are just put in that really have no actual effect on clients or are otherwise disproportionate? Is that proposed condition limited to the minimum of what is required to achieve the legitimate policing aim? Take instructions from your client, make sure that the police's request for bail conditions are based on evidence and not just conjecture or supposition, and make representations to the sergeant. Okay. After the police station, consider whether there are grounds for a complaint or report to the supervisor. Keep in touch with the client, the family members, with the police. Remember that even where someone is released under investigation, the NPCC operational guidance best practice indicates that people should be given updates every 30 days. Again, I know that that is something which is honoured in the breach rather than anything else. So I think we now do have time for a few questions. We've got about 5 minutes left. If there's anything anyone would like to ask either of us.
I've got a few questions have been collated, so it might be easier if I just run through them. So the first one, it's interesting that you mentioned telling the client the time when you speak on the phone. We heard from one of our former clients last week that having no idea of time in a cell makes you feel like a dog. Are there any other small but important tips you can give us that can make a child feel more like themselves in a disorientating situation? Either of you?
So I think one of the other things that I tend to do is to say to them, not just that this is the time, but this is what I'm going to be doing. So I'm going to be checking with the police every half an hour. If we get to X time and I am not there yet, ask the police, tell them that you want to speak to me, because that's the thing that they can't stop. And then at least you get an update. You know, sometimes we phone through, I've no idea whether it's going to get through to the child or not, but it gives them some control because they either expect to see me or they expect to speak to me. Great,
thank you, Sandra. I'm just going to whiz through because we've got 4, so we've probably got a minute each. So it's important to identify at an early stage any vulnerabilities, i.e. special educational needs, speech and language needs, etc. How do you do this?
So the police are obliged to identify, sorry, I've just jumped in there, Matt. The police are obliged to identify that. So you ask them, look for how that, whether the document's been the custody record, that signature on it. Ask the child if you have, you know, got a phone call from uncle in this scenario, ask them about it. The instructions that you take from that child about what they have been doing, because you know you do a lot of talking about understanding them before you get down to what you need to do sometimes. You know, depends on the circumstance, but if you have the opportunity to do that, then you do that. I think that's why also just checking who else knows this child. You know, somebody else in your office may have that information. So checking those things against your own internal systems even are really useful things to do. I don't know if there's anything else, Matt, that you're thinking of.
I think it's just part of the getting to know your client when you're talking to them. Sometimes the questions that aren't ones that you need an answer to be able to provide advice on the allegation are the ones that are the most revealing.
Yeah. So Matt, there's just carrying on with on that train, there's a question that asks you specifically for ideas on ways to build trust with the client at the police station who you might not know.
So a great knowledge of really bad pop culture has served me really well, because there's just, it's so strange, and actually if you can just talk about something that gives you a link to that person, you will see there will be, it's almost like lifting a weight off them when they get to talk about something that they genuinely like, and you have a bit of a back and forth, and that's at least my excuse for watching far too much bad TV, but I think it works.
Yeah, I think there are some other things you can do as well, Aika. So if you know this is a group of children who you are going to be representing, you can start well before, it's before you get that phone call. You know, you can kind of, you know, find, you know, be in touch with the Youth Justice Legal Centre. What can I do? The Stop and Search Legal Project. What can I do? Things that bring you into contact with children, with this group of children, before you need to go to the police station. You can read, there's a whole bunch of books out there. And I think, and I don't know if it did make it into the guide, Aika, but we talked, didn't we, about a reading list for people. But there's a whole bunch of stuff out there that you can read. And if you're not that bothered about reading, you haven't got time, if you look on YouTube, TikTok, all those things, and once you look at it once, it sends you more information about what this cohort is doing, experiencing. You can do all of that before you even get to the police station.
Yeah, no, I completely agree. So there's 2 more questions, so 30 seconds each, right? So no comment interviews. These are sometimes seen as lawyers preventing a child from getting a diversion because they are not making an admission. What do you think lawyers should do about this?
Well, I think if your client has an account to give, and if it is a case where a diversion is likely to be a good and correct outcome, then you need to think about ways in which your client can achieve that result.
Yeah.
And there are many of them, and if it takes doing a short prepared statement and helping the client understand and get through there to get there, then that's absolutely fine. You can get a diversion on the basis of a prepared statement, but it's just making sure that you know what the right outcome is and being able to provide the client with advice to routes to get there.
Okay, final question. How do you manage clients on the spectrum? I presume that means the autistic spectrum in the cells when you know they might struggle with being held by the police. If either of you have experienced that, have you got any top tips you can give in 30 seconds?
So if I knew I had a client who had profound difficulty, I would get to the police station probably quicker than I would otherwise, you know, and maybe ask for help before I get there. Like, I know we all kind of try and keep ourselves skilled up with that, but, you know, is there anybody that can help me upskill myself before I get there? Is another thing that I would perhaps consider, but I don't have any practical tips beyond that, I'm afraid.
I build in more time for attending at the police station, and there are in fact resources, and there are resources that are designed to assist with dealing with people on the autistic spectrum in custody. So find them, look at them.
Yeah, there's quite a lot of information on the National Autistic Society website as well, which we can try and put in the chat if it can be located before the end of the session. But at this point, I have to swiftly move on to our next speaker. But thank you very much. Thank you both. That was extremely informative. I think there was a lot of practical takeaways.
Thank you.
So at this point, I'm going to introduce Dr. Aaron Reliford from New York. Aaron is a practicing psychiatrist with a specialism in child and adolescent psychiatry. He is the Vice Chair for Diversity, Equity and Inclusion and Associate Clinical Professor of Child and Adolescent Psychiatry at NYU and the Associate Medical Director of Behavioural Health at Sunset Terrace Family Health Centre of NYU. He's here to help us all to understand the implications of race on childhood development and trauma. So over to you at this point, Aaron.
Thank you so much. I'm really pleased to be with you virtually. I wish it could be in person. But my talk is not going to be as practical as the one just before, but it has the same principles in mind. I think the sort of whole point of this discussion today, as well as the point of what we were just talking about before, is that there's a presumption that race actually plays a part in the lives concretely of young Black and brown youth. And that presumption is not necessarily something that's, at least here in the United States, and I presume otherwise, sort of taken as a given. But yet it pervades our societies. You may have heard there's been a rash over the past week of shootings here in the United States, two of which, at least last week, were racially motivated mass shootings. And there's been movements in parts of the country to actually limit the amount of discussion about race and to sort of keep it relegated to the past. But as we know, sort of the history of racism, racial trauma, the experiences of really horrific encounters with police by Black and brown youth really have a significant impact on the experiences of these youth. And from a slightly different lens, I wanted to talk a bit about identity development in Black youth here in the United States. And I wanted to start off by discussing the objectives of the talk, which are to really discuss the challenges Black children face regarding the development of their identity, to discuss origins of identity development in childhood and adolescence, and to discuss implicit and explicit contributions from society and their negative impact on identity development for Black children. I want to start off just with a brief reflection for everyone to just think for themselves with regards to your own identity. How has your sense of identity changed over time, from childhood, from adolescence, from young adulthood to now, and what has remained the same? And how have these changes been influenced by your community and your environment? When was the first time you were made aware of having a subordinate identity, from whatever spectrum, from a racial spectrum, from a gender spectrum, from an able-bodied to not able-bodied spectrum, from a religious perspective? And what was the first time you were made aware of the privilege within your dominant identity? In the United States, it's typically male, heterosexual, able-bodied, Protestant, and white, right? And in what ways have you conceptualized the subordinate identities of those whom you care for? So in addition to the sort of general psychiatric work that I do, I'm also a practicing psychoanalyst, and that work in terms of thinking about how one develops psychologically in one's life, particularly from a young age, really combines lots of interests of mine in helping to understand the experiences of Black youth. So with regards to this first question of who am I, and thinking about identity development, Erik Erikson, who's a psychologist and theorist, talked a lot about identity development is actually embedded, not just in terms of like, I am who I am because that's who I say that I am, but it's embedded in a social, cultural, and historical context. It takes place on all levels of mental functioning. And a lot of times the individual judges themselves from what he or she perceives they are into how others are judging them. Beverly Tatum sort of took Erikson's theories and sort of expanded it. She's an amazing author who came and gave talks to us here at NYU. But she has a fantastic book, Why Are the Black Kids Sitting Together in the Cafeteria? And Beverly Tatum sort of talks about in Western societies, or our societies, the sort of self-creation of our identity sort of is experienced in sort of a real concrete way in adolescence. But the foundations of identity development actually starts in childhood. But little kids, they can't really reflect in an abstract way in the way that adolescents and adults can. And so adolescence is where it really comes on board. They have the capacity to reflect on who they are now, who were they before, and who they will become. And the answers to these questions, as adolescents start to churn through them and try to figure out who they are, influences many things in their lives. Influences the romantic partners that they choose, the work that they do, where they live, the belief systems they ultimately embrace, and the violence that they experience. You know, I give this talk a lot, and I always talk about there's a play and a movie called American Son, and in the play it takes place in a police station, and it's a Black mom and a white dad, and what they're doing is they're sort of going back and forth, trying to figure out the sort of circumstances leading them to where they are in the police station. Their son is missing, and how they got to that point. Ultimately, the way they were perceiving it was from their own racial backgrounds and perspectives in terms of how their son made the choices that he made. And ultimately, the son was killed, shot by police. And ultimately, that was sort of a really shocking and jarring experience. But this young man had made choices in his life that were playing off of the differential perspectives that his parents were putting on him, and it ultimately chose the wrong crowd to engage with that led him to his death. And so the violence that one experiences can actually be related to these choices that kids are making in their adolescence regarding their identity. And so when we talk about identity and reflecting on those questions that I put out before, sort of identity is embedded in societal designations of what the norm is, right? So the norm, as I mentioned, in the United States, typically are male, heterosexual, able-bodied white men And these individuals in these relative places of their privilege, they have the status as the norm. And the other is typically determined by a salient aspect of difference related to that. Now, Beverly Tatum goes on to talk a bit about sort of the subordinate groups relative to those identities are labeled as defective in significant ways, such as Blacks are less intelligent, and that's typically in the form of stereotypes reflective of racism. And dominant groups don't like to be reminded of inequality, don't like to be reminded of the fact that they have this privilege within society. And the dominant groups don't typically know what the experience is of subordinates, again, except in stereotypes that are received through forms of media. But the subordinate groups actually tend to have years of internalization of the dominant perspective and have sort of at times come to incorporate and internalize aspects of that dominant perspective, which can create conflict internally and internalization or manifestation of self-hate. So this graphic I like to show because, again, getting back to that idea, most of us, when we think about our identity, we think about we choose who we are, we choose what we tend to be, and but actually it comes from many different places that are separate from just that, right? So certainly we're taught in our individual cultures and subcultures about aspects of that are important to our background that lead us to sort of become part of who we are. We also compare our developing selves to those in our environment as we're coming up to help further hone our identity. But really, a key factor that is not often talked about is we are also who we are based off of what others think that we are. And that comes into play in terms of how society and various societies has given us prescribed roles based off of what they are seeing, be it based off of our race, be it based off of our gender or otherwise. Shifting gears just a little bit, racial identity in very young children, kids are often not thought to be competent or have the capacity to really think about race. And typically when race is brought up, at least in the United States, by a young child, it's actually shushed. And the parents of these children, who are typically from the dominant racial group, tend to be embarrassed. They feel that the racial questions, such as a child may come up, why is that person dark? Did they drink too much chocolate milk? And the kids are chastised, and other parents who are looking at the parents are thinking, wow, your child is saying these things because of something that you're teaching them. And it's not necessarily something that the child is able to really understand in terms of what's going on. But in reality, that's a myth. And kids actually understand and think about race at earlier ages than we tend to think about. They are able to categorize by race and gender from very early ages in differential capacities. So 6-month infants from studies have been shown to look longer at unfamiliar faces of different races than their own. 2-year-old toddlers and other studies use racial categories to reason about people's behaviors. And 3 to 5-year-olds categorize themselves and others by race and express racial bias as well. By kindergarten, so this is 5 years old, kids, they show some of the same implicit, meaning like sort of unspoken or unconscious racial attitudes that adults in their cultures hold. And they associate, they've come to associate some groups in their society and in their neighborhoods with higher status, and that tends to be associated with more positive value. And this has been shown in studies to be mimicked in sort of created scenarios in which just a few minutes of exposure to information about fictional groups that have different socioeconomic status, the kids tend to prefer the wealthier group or the more preferred group. And so we're going to talk a little bit about sort of the origins of this and what this is about. And to do that, a lot of the studies actually sort of examine and try to understand the perspectives of children and actually adults. I do a lot of work, as was mentioned, in diversity, equity, and inclusion, and a lot of my work looks at examining health disparities for marginalized youth and marginalized adults. A lot of times that is related to implicit thoughts and implicit bias, and ways of getting at that are through various tests, one of which is the implicit association test. And what that measures essentially are thoughts, as I mentioned, that are out of awareness and that are operating outside of conscious awareness, but certainly influence behaviors and ways of engaging with the world. In contrast, explicit thoughts are those that we are aware of and that we verbally express. And so with regards to racial identity and implicit social preference in young children, I want to contrast that by thinking about the development of explicit intergroup preferences. So these are sort of verbal expressions of young children in terms of what they are saying that tend to be thought of as reflective of their internal thoughts and feelings. And there was a study that showed that from the age of 4, kids in the US and the UK verbally expressed negative attitudes and stereotypes towards racially marginalized groups. But interestingly, these expressions tend to decrease in middle childhood, and mostly they're gone by adolescence. And there are a couple explanations that are thought of regarding that. One is they mature. They're able to think about people in less two-dimensional ways and think about people more flexibly. They think less stereotypically, and they can hold lots of different representations of people in their mind, not just sort of caricatured ones. But the other thought is that they are sort of more conscious of social norms, and they're less apt to sort of break those social norms based off of what they're learning in their environments as they move around. Shifting to development of implicit thoughts, right? There is not that dissociation. There's not that early development that then extinguishes over time and shifts, particularly with regards to dominant group or the dominant group preferences, right? There's an early emergence of in-group with reference to the dominant group preferences that does not extinguish over time. And that sticks with folks implicitly, again, out of their awareness. And what happens is that there's a very early growing awareness of what actually is happening in their society. They're not necessarily reflecting on it consciously, but the kids are becoming aware of it. You know, they see in their neighborhoods who are the people that tend to be the ones that are janitorial staff, who are the ones that tend to be the people driving the buses, who are the people that tend to be the doctors or the nurses or the teachers, who are the people that tend to not have jobs, who are the people that tend to get harassed, who are the people that tend to get discriminated, right? And then they put themselves within that as well. They know sort of their backgrounds in many levels, and then they start to sort of compare who are they relative to these groups that have preferential sort of status within society and otherwise, right? And this sort of occurs at a very young age. What happens also in this early emergence is that it's really shown that it's not just simply sort of baked into teachings that people are actually given when they're young, right? It's not just that young kids are making these judgments and associations and categorizations because their parents are telling them or their grandparents are telling them. That stuff reinforces what they are already developing. These thoughts are developing on their own. Kids are master categorizers. They come to see these categorizations and they come to start to put these sort of representations in different slots, and then they develop their own opinions and their own thoughts that at times is reinforced by what their environment are actually saying. So the two factors, just to review, the kids rapidly tend to develop a tendency, they favor their own in-group, whether they're dominant or not, right? Over time, the non-dominant groups tend to actually favor and prefer the dominant groups, right? But also kids are very sensitive to relative social status, as I've been mentioning, and where they fall within the hierarchy, and then they start to compare. And there are a couple studies that actually show this. 6-year-old children from socially advantaged dominant racial ethnic groups in the US, the UK, and Japan, they actually show robust implicit preference for their in-group through the children's implicit association test that persists into adulthood. But kids from non-dominant groups, racial or otherwise, they initially show in-group preference for their group, but this later changes to an implicit preference for the dominant group, and that persists into adulthood. So you see there's this discrepancy in terms of how kids from these non-dominant backgrounds, these racially marginalized groups, come to view over time that they are actually not preferred implicitly, and they come to prefer the dominant in groups. And there have been many studies over time in the United States and otherwise that have actually shown this, and how Black and brown children tend to prefer, say, the dolls who are not Black and brown, and they prefer white dolls, so forth and so on. And the question that I want to throw out just is like, what are these kids as they are shifting in their implicit thoughts, learning about themselves? How might a 6-year-old from a different group view themselves differently, right? From sort of the dominant group and the non-dominant group. How might they look at themselves differently? How might it impact the development of their identity, how they see themselves in relationship to the world? And this I mentioned before is that these racial beliefs, they're not significantly, and this is another study, related to the ideas of their parents. And these kids are just motivated to learn and conform to broader cultural, social norms, and they adapt, right? And how do they get this information, right? They're seeing it, right, in their immediate environment, but also all around in media, books, movies, TV, social media, as I mentioned, occupational associations. All of these things are teaching and giving messages that are just soaked up by kids, and ultimately they attach meanings to these categories without adult instruction, and then they pick up on the privilege and preference of whiteness in Western society. So, you know, I sort of implicitly, on some level, talked about cultural socialization, which is that process of learning to adapt in your society and understand the rules and regulations of your society to allow you to be able to function. But there's this related topic, which is racial socialization, which is tends to be the responsibility of parents, but it should be all of our responsibility. It's taking that presumption that kids of marginalized backgrounds in these societies will be discriminated against, and teaching these kids how to function in a racially inequitable society while maintaining racial pride and positive self-esteem. The other implication is that kids who are developing on, in terms of their identity, getting messages about who they are and who other people are sort of getting conflicting messages, and then they come to feel poorly about themselves, and that reflects on how they engage with the world. So you have to actually teach kids explicitly how to know that these messages are out there, that these messages are wrong, and to figure out ways to instill pride and positive sense of self in these kids. And it's very important for parents of color. Most typically, these conversations are happening with parents of color for their children, to really do this, because it just won't happen on its own. And for children and parents who are from the dominant background, white parents and white children, it's important to talk about race. If race comes up, and this seems like a basic thing, don't shut it down because it's thought to be something that is taboo or something that's a bit too complicated or complex for children. Kids, they understand race, they categorize based on it, based off of this from a very young age, and have open, honest, frequent, and developmentally appropriate conversations with these kids, and emphasize the multiple dimensions of individuality, not just race. And that's going to help these kids to really grow up and understand things related to structural racism and how that impacts how these thoughts are instilled in the minds of children and adults over time. I want to shift to explicitly talk about structural racism. Again, that's what sort of on the one hand is explicitly sort of assumed in our discussion. But President Lyndon Johnson, who was an interesting figure, but was actually a great figure for the development and passage of the Civil Rights Act in the 1960s, as well as the Voting Rights Act. He really got it. And I want to talk about his quote and a couple others as we go through and think about it. He says, "I'll tell you what's at the bottom of it. If you can convince the lowest white man that he's better than the best colored man, he won't notice you're picking his pocket. Hell, give him somebody to look down on and he'll empty his pockets for you. he got it. He understood it, right? Isabel Wilkerson, who wrote a book, The American Caste System, talks about this also even more explicitly as a mean of assigning value to entire swaths of humankind. Caste guides each of us. It embeds into our bones an unconscious ranking of human characteristics and sets forth the rules, expectations, and stereotypes that have been used to justify brutalities against entire groups within our species. In the American caste system, in contrast to the caste system as it existed in India, the signal of rank is what we call race, the division of humans on the basis of their appearance. In the US, race is the primary tool and the visible decoy, the front man for caste. Bobby Harrell also talks about structural racism and the cycle of socialization, highlights that we're born into a set of social identities, and these social identities predispose us to unequal roles in the dynamic system of oppression. And then we're socialized by these powerful sources in our world to play these roles that are prescribed to us. And for those who are from the non-dominant backgrounds, those who are typically oppressed in society, there are really dramatic consequences for attempting to break out. And for those who are from the dominant backgrounds, you're sort of forced by sort of social pressure to sort of maintain the status quo. In the United States, these things were emphasized after slavery through what are known to be Jim Crow laws. And those were actual laws on the books that sort of kept the status quo in place, that sort of kept this system of racially based segregation in place. It was kept in place legally, but it was also kept in place paralegally through organizations like the Ku Klux Klan, the KKK. Economic freedom was restricted, personal freedom was restricted, political rights were restricted, and this was all codified and exists even now in ways that people don't think about and understand all throughout many systems. The housing system, redlining was a practice in the United States where Blacks could not actually get loans to get housing in certain areas, and that restricted housing opportunities. The criminal justice system, which we've been talking about today, is also a large factor. Public health disparities, education system, and banking, it's throughout. And so if we go back to this idea of identity development and who am I, and sort of what society is telling us who are marginalized, who we are, there's a lot to contend with. And in this last study, second last study that I want to talk about, Kirkland Vaughn's talks a lot about how Black boys in the United States are portrayed as unwanted foreign violent subjects about which white America must really be constantly vigilant. And this is the case in many societies as well, right? And there are societal stereotypes that exclude them specifically from educational opportunities, employment opportunities, and other opportunities. And there's a cycle that existed all the time from slavery up until now, and it relates and it sort of leads to intergenerational trauma, right? So these direct legacies of slavery are kept alive through intergenerational trauma, which I'll talk about in a minute. At times, sort of the position that these Black boys are in, or these Black children are in, sort of is reinforced by sometimes non-adaptive responses to the hostile culture in which they're in. And that sort of reinforces deep-seated racialized beliefs. And then folks are thinking, oh, well, this is how they are. This is what they are originally. But actually, it's a reactive cycle, right? There are many sort of terrible environmental conditions that many Black children are growing up in. There's lots of shootings and homicide, market increase in arrests and incarceration, unemployment, lower life expectancy. So the environment is sort of rife with situations that make it really challenging to live and exist in a way that's equitable to others. This mechanism of intergenerational trauma, from a psychological perspective, you have these traumatized self-images from the past that are implanted in the minds of each generation, and it's passed down from generation to the next. It's not thought about, it's not processed, and it's unformulated, mainly because these experiences are too humiliating to be thought about and talked about. My parents talked about how their grandparents never talked about slavery. It was something that's just too horrible to actually be thought about. And so it's passed down in these degraded self-images, and it gets implanted in the group identity. And in each generation, it just continues on and on in the form of cultural interjects, which is internalization of historical past about which you're not really aware of, but you're beholden to. It passes on in terms of anxieties and fears that you're not really aware of, through fears of loss, right? Through societal violence or re-traumatization, right? And it gets played out in enactments through abuse and passing down of intergenerational trauma in other ways. So I want to move forward and talk a bit about one, and this is the last thing I'll talk about, which is one concrete representation of all of this negative internalization of all of these factors is the crisis of Black suicide in the United States. There have historically been lower levels of suicide in Black youth in the US, but over the past couple of decades, compared to their white peers, the rates of suicide for Black children has been dramatically increasing. For Black kids under 12, they're more likely to die by suicide than their white peers. It's the second leading cause of death in Black kids 10 to 14, the third leading cause of death in Blacks 15 to 19. And until recently, there haven't been really specific studies that looked at what is the connection between discrimination and suicidality. It's been assumed that that's the case. However, this one study, which is a great study that just came out, sort of highlighted this. Black youth in the study reported more discrimination and higher suicidality rates than non-Black youth in the context of high racial and ethnic discrimination that was associated with suicidality, even when comparing other forms of discrimination and other forms and other risk factors for suicidality. Racial and ethnic discrimination was associated with suicidality, but not being Black themselves. So with that, I'll actually pause because I know I'm probably close to being over time, but I want us to really think about in terms of these societal pressures that are implicit, that are structural, that are related to long historical past of racism and discrimination, and how there are implicit messages that are implanted in the minds of these children that are passed on and played out in the way that they feel about themselves as they develop. So with that, I'll pause and turn it over to questions.
Thank you so much, Aaron. We actually have run out of time for questions, but I think we could squeeze in just one, which was around the advice that you would give to white parents about how they navigate what you describe as shushing their children and not talking about race and feeling that it's impolite for us to be British, polite.
Absolutely, absolutely. I mean, it is seen to not be polite, but I think that you don't necessarily have to have these conversations in public, though you should. But having long, extended conversations about the history of racism and about how it's really important to show that there are those in society that are discriminated against and treated differently just because of superficial characteristics, and sort of really help them to think multidimensionally about specific individuals. So I think that's just a really important point.
Thank you very much. I was totally engrossed in your slides as a mother of two Black boys, and I forgot I was actually chairing this event and had to get back into my chairing head. But thank you ever so much for joining us today.
Absolutely.
Now I'll need to swiftly move on to our next speaker. Understanding the background to racism is extremely important, and all criminal practitioners will have experienced racism on behalf of their clients. For many of us, the question is always, well, what can I do about it? Luckily, we have Shomik Dutta from Bat Murphy, who will help us criminal practitioners think about how we can challenge these things outside of our direct representation. Shomik specialises in pursuing civil claims and public law challenges against the police, and in enforcing the rights of those subject to unlawful immigration detention and unlawful deportation. He acts for the families of individuals who have died in police and prison service custody. He is currently instructed by more than 40 bereaved families, survivors and residents in the Grenfell Tower public inquiry and associated legal proceedings related to the fire on the 14th of June 2017. Over to you, Shomik.
Thank you for that introduction. I'm just going to share my screen now for the slides, so bear with me. And hopefully that has worked. The purpose of my talk today is to ensure that when you're representing detainees at a police station, you've got one eye on whether or not there is a viable challenge to their detention, or any of the matters that arise in the course of their detention, in particular, a police caution. I will start with police cautions because colleagues earlier have dealt with issues around police powers on arrest. And hopefully by the end of this talk, you'll have a good idea as to whether there is a viable cause of action against the police, and if so, on what basis. So starting with cautions, as you all know, an officer may offer a child a youth caution if there is sufficient evidence to charge them with an offence, if the child properly admits guilt before the offer is made, and they don't consider that the child should be prosecuted or given a conditional caution. Now, the important thing to think about here is that what any challenge will be based upon is the decision to offer the caution. So it's at the point that the offer is made, that is your public law decision that you'll be seeking to challenge. And at that point, there needs to have been a full and frank admission to an offence. Now, what that would mean is that it can't be an equivocal admission. For example, if someone is acting in self-defence and they say, I did this, I used force, but it was in self-defence, that's not going to be sufficient. Another thing to bear in mind is that there will be times when a police officer will sidle up to a child in detention and say, look, you know, before the interview, they may well say, we could prosecute you for this, but if you admit the offence, then I can give you a caution. Now, that in itself would vitiate any subsequent admission. By that, I mean it would make the offer of the caution unlawful because there had been an inducement to the detainee to admit the offence. So bear in mind what has happened prior to the offer of the caution. Has there been an inducement? Has there been a full admission to the offence? Those are the two bases, in my experience, upon which you will find a viable challenge to a caution. And it's important to bear in mind the importance of challenging cautions where they have been unlawfully administered. The judicial review is one way in which to do that, and obviously if you are going to pursue a judicial review, you need to act promptly and certainly within 3 months of the date of the decision. However, even a caution that has been offered many months before could be subject to a challenge, because the policy on data retention in relation to cautions is one which allows a challenge out of time, because in essence, the retention of information about that caution on your police record is an unlawful processing of data. By that, I mean that the retention of that caution on your record is a retention of data that you have admitted an offence. If it comes to light that actually, upon review of the interview transcript, you can see that there has been no full and frank admission of an offence, then that is something that is unlawfully retained data and should be challenged, and can be done so out of time. But obviously, if you can be in time, then you would need to be. Now, moving on to civil claims, I wanted to talk about what the causes of actions are and time limits to bring claims. The first is false imprisonment, and it's the burden there is upon us to show that there has been detention. That does not need to be physical. It can be a threat on the basis that if you were to leave, then you will be detained, a threat of immediate force for detention. The burden then shifts to the defendant to establish the lawfulness. And we've already heard from colleagues about necessity being one of the criteria the police will need to satisfy, and also reasonable suspicion. And examples of false imprisonment claims can be those arising in the course of a stop and search, or in the course of an arrest. Now, what one needs to think about is the test for lawfulness is really based upon what is actually in the mind of the officer at the point that an arrest is made. And that makes it difficult sometimes to challenge an arrest where an officer has relied in good faith on information provided by a third party. So generally speaking, we would find that a viable claim against the police for false imprisonment would arise where it is the officer's own knowledge, or things that ought to be in their knowledge at the time that the arrest is made. It is more straightforward for an officer to justify a detention if they have been given information by a third party, whether that's an alleged victim or by another police officer. We've explored honesty and reasonable suspicion, honest and reasonable suspicion, and then moving on to necessity. Now, it was the case previously that it was quite difficult to challenge arrests on the basis of a lack of necessity. And that necessity, you'll be aware, is where it's necessary to enable the name and address of the person to be ascertained, or to prevent physical injury, protect a child or vulnerable person, etc. However, just today, there's been a case, judgment has been delivered in the case of Tark v Chief Constable of Nottinghamshire, which I thought I'd bring to your attention because it's specifically on the point of the extent to which a challenge to the necessity of an arrest can be pursued on behalf of a child. And in that case, you'll see that the judgment has said, given the other surrounding features of the offence and investigation, it's difficult to see how the arrest of a sleeping 14-year-old boy at 1:30 a.m. to ensure a search of his bedroom and to enable him to be questioned after 8 a.m. could conceivably be considered to be necessary as opposed to simply convenient. And this is a very important judgment because it sets a precedent now that the timing of an arrest can be taken into account when considering whether the arrest of a child was necessary. You'll also be aware of the requirements that a child should not be placed in a cell unless there is no alternative, and there shouldn't be overnight detention unless no alternative as well. And so those are matters to take into account when considering whether it is truly necessary for your client to have been arrested. Next, we come on to assault and battery. And for that, we need to, as the claimant, establish that force has been used or that there's an apprehension of the immediate use of unlawful force. This can be any touching, the use of handcuffs, and also the taking of fingerprints at the police station. It will be unlawful if it's unreasonable, unnecessary, or excessive. It's important when you're representing somebody in this circumstance to ensure that they gather as much evidence themselves as they can, and by letting you know where to get that evidence from. So in the case of either an arrest or a use of force, it's important to think about where are CCTV cameras locally. Do a site visit, have a look at the area. It's not just body-worn video that's useful, because sometimes, as we know, those body-worn cameras are not turned on, or they are mysteriously faulty on the occasion of the officer using excessive force. In relation to evidence of injuries, always advise a client to attend a GP or hospital, depending on the nature of the injuries they've suffered, so that there is some evidence of it. And also ensure that photographs are taken of any injuries by someone who can provide a statement at a later date, setting out when they took the photographs and where they took them and their relationship to the claimant. Ideally, it would be an independent person doing it, but anyone who is a family or friend would suffice in relation to that. Now, in relation to the use of force, you'll know the police have the power to use force to make an arrest, to prevent crime, and in self-defense or defense of another person. That force must be necessary and proportionate. So those are the matters to bear in mind when seeking to challenge an assault, to bring an assault claim in relation to the use of force. Was the force really necessary? Was it proportionate? Think about obtaining the FME records in relation to your client as to what injuries they suffered. Ask in disclosure for any injuries suffered by the officers, because quite often we'll find that the officers themselves have suffered no injuries and your client has suffered numerous injuries, and yet they are the ones who are claiming assault in the course of an arrest. I should say that in relation to civil claims against the police, what we generally find, because you need to look closely at what's in the mind of the officer, those claims which are most likely to be viable and successful are ones where it is based upon an officer's own knowledge or statements. And so where officers arrest for example, assaulting them, or obstruction, public order act offences of that nature are the ones where a police officer is able to detain and arrest without any reliance upon a third party's account. And so those are the ones where you're most likely to find that there may well be a civil claim viable against the police based on an officer fabricating evidence in their notebook, fabricating the extent of threat or force that they perceived on the part of your client. Moving on to Human Rights Act claims, the key Human Rights Act claims that could be pursued are here. And here we're looking at Article 3, Article 5, Article 8, Articles 10 and 11, and Article 14 in relation to discrimination. Now, Article 3 claims can be pursued in relation to seriously negligent police investigations or where there is an unlawful strip search, which is particularly humiliating. In relation to Article 3, it is one of the articles which places a positive obligation on the police to ensure an effective investigation where there has been a breach of Article 3. So, for example, there are claims which we often regrettably have to work on where you will have a victim of crime who is your client, who's been the victim of a very serious assault, but that has not been properly investigated. Rather, your client ends up being arrested and investigated because they're black, brown, or racialized child and the assailants are white. And so in those circumstances, you could consider a claim under Article 3 as well as Article 14. Article 5 claims are those in relation to detention and can be combined with a false imprisonment claim. They're particularly useful to pursue where you have that circumstance of a third party giving information to a police officer. So one police officer tells another police officer, because then it is a claim against the force as a whole, as opposed to focusing just on the mind of the individual officer who made the arrest. Article 8 claims are pursued quite often where you have an unlawful search of premises, where, for example, the police have not carried out adequate checks to ensure that your client was actually, the person they were looking for was actually at the address, and where they've raided your client's home in error. Articles 10 and 11 are often brought in relation to protests, where there are arrests at protests where there's been an interference with Article 10 and 11 rights. And obviously Article 14 claims in relation to the right to be free from discrimination. And that can be pursued on the basis of stop and search or arrest, where it's clear that race is a factor. Turning to Equality Act claims, bear in mind all of the protected characteristics that are listed there. And bear in mind the types of discrimination. And those are direct discrimination, less favourable treatment on grounds of race; indirect discrimination, where it's a practice or procedure applied to all, but where there's a particular detriment suffered by those who have a protected characteristic; or a failure to make reasonable adjustments. Now, when investigating this type of case, look for evidence of how your client is described by the police. It's pretty rare these days to find officers brazenly using racist language. And more often than not, those investigating police complaints won't actually understand that racism isn't that easy to establish, and therefore you need to look underneath the surface of what's written in police officers' notebooks. So, for example, if you see evidence of adultification, of your client being described as much bigger than they are, as much stronger than they are, as having superhuman powers, as I've seen in all too many notebooks, even when it comes to children, those kind of bits of evidence are evidence of race discrimination and stereotyping, which you should bear in mind when pursuing, when deciding whether to pursue a claim under the Equality Act. In relation to a failure to make reasonable adjustments, that can be where officers are aware that an individual has a disability but failed to make reasonable adjustments nevertheless. In particular, if a client suffers from autism, then in those circumstances, there can be a particular fear of laying of hands upon them. And where police officers are aware of that, they need to make reasonable adjustments to it. And there can be a failure to make reasonable adjustments, giving rise to an Equality Act claim. Next, we move on to malicious prosecution. And the constituent elements of this are, first of all, that there has been a charge. Your client has been charged with a criminal offence. Secondly, that there would need to be a successful termination of that prosecution in the claimant's favour. And that can be either by there being a discontinuance before trial, or an acquittal, or, as sometimes happens, a case being kicked out at half time. So where there's a no case to answer finding. Now, in those circumstances, you'll need to consider whether there's a lack of reasonable and probable cause. So either the prosecutor did not have an honest belief in the claimant's guilt, which is a subjective test, or a person of ordinary prudence and caution would not conclude, in the light of the facts honestly believed at the time, that the claimant was probably guilty of the relevant offence. And that's the objective test. Now, the court can look beyond the information the officers had available to them, to the information that they would have obtained had they taken reasonable steps to investigate, for example, following up obvious inquiries. One of the constituent elements here is malice. Malice can be inferred from the lack of reasonable and probable cause, but not vice versa. Malice is defined as something other than the desire to bring the accused to justice. So if you have officers fabricating evidence in their notebooks as to your client having acted unlawfully when they plainly had not, then that is malice. But if I can explain it by way of an example as to how you can infer malice from an absence of reasonable probable cause, but not vice versa. Let's say your client is arrested by a next door neighbour who happens to be a police officer, and that next door neighbour has a vendetta against your client. Just because they have a vendetta against your client, it doesn't mean that on a particular occasion, they may not have had reasonable and probable cause. And when thinking about who the prosecutor is in these cases, it is those who set the train of the prosecution in motion. By that I mean it is the police officers who lay evidence in support of a charge. One thing you'll need to bear in mind is when assessing damages, what was the damage to the person's property, reputation, or freedom? Yeah, obviously, if a person has been detained, then that will give rise to a greater level of damages. But a constituent element is that there has been a damage to a person's property, reputation, or freedom. Other claims to bear in mind are misfeasance in public office, where you have a public officer who acts with reckless indifference to their lawful obligations and reckless indifference to the consequences and anticipated loss. Now, this is a civil claim that could be pursued, for example, where a caution is issued, where it's unlawful and the officer is well aware that it's unlawful or are recklessly indifferent. Negligence claims can also be pursued, although are more difficult. Trespass to land claims are pursued in circumstances where there is an unlawful search to premises. And finally, breaches of the Data Protection Act. A Data Protection Act claim could be pursued, for example, where an individual is arrested on the basis of a warrant that's been inaccurately or improperly issued or maintained. Even though the individual officer would have had reasonable grounds to suspect based on the warrant, the claim can still be pursued against whoever issued the warrant if the warrant is defective under the Data Protection Act. So the outcomes from civil claims are obviously compensation, an apology or restorative justice, and declaratory relief under the Human Rights Act or the Equality Act. And it's important to bear in mind that an apology or restorative justice can be equally, if not more important to clients than damages. It is a public recognition that there has been wrong done to them, that they can then show anybody who witnessed the arrest, anybody who was aware of the arrest, that they had not done anything wrong. It's very valuable to clients. And one thing to remind police forces in litigation is, from your client's perspective, quite often they will want to have their day in court because they will want to have that level of public vindication. It's important to bear in mind limitation when representing anybody in a civil claim against the police or in a judicial review. And I've set out there what the limitation periods are. But bear in mind that when you're representing a child, the clock starts to run on the 18th birthday in relation to civil claims, although not in relation to a judicial review. That will still need to be no later than 3 months and promptly. Finally, we move on to police complaints. Now, the police complaint system is simply defective. It's not fit for purpose. However, it may be that one does want to pursue a police complaint because it is still the only way that you can actually have officers themselves potentially disciplined for their misconduct. It's important to set out the facts, who, what, where, and when, but bear in mind the risk of prejudice to a civil claim by setting out too many facts before you've actually seen disclosure in the case. You should set out how the events described are in breach of standards of professional behaviour. And on that front, I'll finally finish with what those standards are. And those are that officers should act with honesty and integrity, authority, respect and courtesy, equality and diversity. There should not be unlawful use of force, and the others are set out there. Now, many of these do give rise to a civil claim in themselves, and it's up to your client to decide really how important it is to them for the officers to be disciplined, for there to be some chance of that happening as to whether they decide to pursue a police complaint in addition to a civil claim. I hope that's been helpful. I'll stop sharing the screen now, and I think we'll move over to questions if there are any.
Thank you so much, Shamik. There was a whole checklist of things for us to consider as criminal practitioners. And unfortunately, we don't have time for questions, otherwise we won't be able to fit in our last speaker. But we will direct people your way if necessary. We often get queries that we do divert straight to Bat Murphy, so we'll continue to do that, and you particularly following this. So thank you very much for your contribution. Lastly, but of course not least, it is my pleasure to introduce YJLC. The statistics are clear that Black, brown and racialised children are diverted from the criminal justice system less than their white peers. How to bring equity to this group is what BAMI is going to help us with. BAMI works at the Centre for Justice Innovation, working collaboratively with practitioners and police to support and enhance innovations currently taking place within the criminal justice system, particularly within youth and adult diversion. BAMI has frontline experience working as a warranted police officer for the Metropolitan Police and as a caseworker for a gangs and violence prevention charity. So over to you, BAMI.
Thank you, Icon. Thank you for having me today. So I'll if you can go to the next slide, Veronica. So before I start, I just want to outline what I mean when I refer to youth diversion, which I'll be talking about today. So this is what the Youth Justice Board, youth offending teams and police hopefully refer to when discussing diversion as an outcome for youth offending. So youth diversion is a set of informal non-statutory practices in which children and young people are provided the opportunity to avoid a statutory out-of-court disposal or court prosecution and a criminal record if they complete community-based interventions. And this is normally voluntary, informal and light touch. In other words, diversion sits outside of formal criminal justice processing, such as youth cautions and youth conditional cautions. So while criminal lawyers often think that cautions and conditional cautions can be seen as diversion, this is not what I'm referring to when I use this term. So diversion will usually result in a community resolution or a no further action, which can be recorded by the police as outcome 22 or outcome 21. And though it can be used to prevent further offending, it is not prevention tool, as there has to be a threshold met where the child has committed or been linked to an offence and there's enough evidence to prosecute. Also, I'll be using the term BAME for Black, Asian and minority ethnic children during this presentation, and though we recognise that this term can be considered problematic and it arguably flattens different experiences of the justice system and other racialised social systems between individuals in different racial and ethnic backgrounds, and I know that this term is obviously does not refer to a homogenous group of people. So where possible, we've attempted to disaggregate our findings in regards to specific ethnic backgrounds, and I will refer to different ethnic backgrounds when necessary. Next slide, please. Next slide, please. Thank you. So here's just a few quotes. Sorry, go back on, thank you. That kind of just talks about how we know that how the research essentially says that criminal justice processing can make young people who are involved in crime more likely to offend again. And formal criminal justice processing extends and deepens young people's criminal careers, and outcomes get worse the further young people progress into the system. And we've seen here from the House of Commons Justice Committee that says a growing body of evidence suggests that diverting children from formal criminal justice processes, it's a protective factor against serious and prolonged offending. Therefore, diversion should have long-term impact on youth crime levels. And obviously, for the interests of justice, it might make formal processing necessary for some young people, but when we use it, we should be aware that it does not always increase safety for the public and it's not always in the best interest for the child. Next slide, please. So in the Justice Select Committee's 2020 report, Children and Young People in Custody, Part 1, Entry into the Youth Justice System, the committee noted that disproportionality is visible in every part of the system. And Justin Russell, Her Majesty's Chief Inspector of Probation, and they inspect the probation service and youth justice system. he told the committee that somehow the system seems to be better at diverting white children away from the formal criminal justice system than it is for BAME children and young people. And despite downward trends in the numbers of children and young people in the youth justice system in England and Wales, the proportion of Black, Asian and dual ethnicity boys has been increasing. The Youth Justice Board recently found that the proportion of first-time entrants into the criminal justice system from a Black background has increased over the last 10 years, from 10% to 18%, and the proportion of first-time entrants from an Asian background has increased from 5 to 8% over the same period. And also the proportion from other ethnic background has increased slightly from 1 to 2%. Furthermore, BAME children and young people are more likely to escalate through the system. So in 2018, they made up 31% of arrests, 35% of prosecutions, 53% of custodial remands, and 51% of the custodial population. And across the whole system, the proportion of BAME children in the youth justice system is now almost double what it was 10 years previously. And we all know, I'm sure everyone here knows that, you know, Black children are overrepresented at every stage of the youth and adult justice system in England and Wales. Next slide, please. So while we know that the evidence strongly suggests that youth diversion is beneficial for children who go through it, and it has been shown to reduce reoffending in inequality in access to and engagement with youth diversion is likely to have a material impact on disparities later on in the system. So with these concerns in mind, in 2020 to 2021, we interviewed youth offending team staff, police, solicitors, and young people and their families in an in-depth look at racial disparity in youth diversion in 2 local authorities in England and Wales. And due to COVID restraints, we only interviewed a small sample, but we found that Black, Asian, and minority ethnic children, access and engagement with youth diversion was likely to be negatively impacted by the following factors. So the first being that youth diversion can operate in a climate of mistrust. Practitioners recognize that there can be a climate of mistrust in a criminal justice system and other government interventions felt by BAME children. And in their view, this is a quote from a yacht worker, if in their view, they've not had a good experience with the authority, police, schools, social workers they've been involved with their family, they're going to be far more wary of us coming in and working with them. Another barrier could be formal eligibility criteria. So we found evidence that there are specific eligibility criteria, such as the requirement for a formal admission of guilt, restrictions about the number of prior offences, which can result in unequal access to diversion for BAME children. And there's evidence to suggest that some minority groups can be subject to tighter surveillance. So professionals noted and suggested that young Black males were often specifically targeted by the police, leading to repeat offences being recorded. And this additional surveillance can create barriers to Black boys especially, and potentially other targeted groups accessing diversion, as some schemes restrict if multiple offences are recorded. And actually an area that we worked with would not allow a child into their diversion scheme if the child had more than one offence. And you know, there's no real evidence that points to prior offences impacting a child's engagement. So we worked with them to understand this, and they've since changed their criteria. So though it can be a barrier, we're seeing a lot of change and flexibility in this area. And another barrier would be lack of knowledge about the benefits of youth diversion. So a lack of information can result in BAME children and young people disproportionately failing to access diversion. And this is a quote from a solicitor who said, actually, I think it's probably something that we should know a bit more about, because the youth will say to us, what does a diversion intervention entail? And I can never answer that question. Next slide, please. So as I mentioned, due to multiple lockdowns and restrictions, we weren't able to interview as many children as we'd hoped. So in response to that, we're currently undertaking a second research project into children's access and engagement with diversion and out-of-court disposals, with a more in-depth exploration of young people's experiences in relation to their ethnic background. So this is called the Young Voices Project. And these findings are still emerging, and we're hoping to complete our project late summer, and I'll be sure to share that round with everyone here once it's out. And it was really interesting just to hear about some of the children's experiences and some of the trends we're starting to see from our interviews, such as some children are not aware of why they need a solicitor or what solicitors do. Some children do not understand the legal process and the outcome that they should expect to receive, what it entails. And some children aren't clear of why they gave a no comment interview. And this could be influenced by family and background, but also solicitors seem to be a driving factor around that. There seemed to be a lack of child and developmentally friendly explanations about the legal process. And interestingly, we found that some children comment on the impact of the ethnicity of the solicitor on their engagement. So we've got some quotes from young people here. Next slide, please. Great. And so some of the recommendations that we made, and as we said, these are still emerging, so subject to change. But we found some principles for practice that can also be applied to out-of-court disposals, not just diversion. So awareness of local diversion schemes. Each area operates differently, but most, if not all, youth offending teams will have a diversion scheme operating locally. And I would recommend finding out who the point of contact is, or asking the scheme, what is available, what kind of interventions your client might receive. We've worked with a number of yachts and police forces across the year, so you can also reach out to us as well if this is something that you struggle to find. Communicating with families and children effectively. We've seen children not being aware of the outcome of their case, what's expected of them or next steps. We've heard children being given incorrect information about criminal records, such as if you sign this caution, you won't have a criminal record. So there's a lack of understanding on the implications of a criminal record. And this is across all areas of the justice system and not just specific to solicitors. But as the child's defence, there's an opportunity to give clear and concise information about diversion and out-of-court disposals and the implications, ensuring that it's not full of legal jargon, and also that the child understands. So checking understanding, whatever this might look like, if it is asking the child to repeat back what you've said to them, asking them if they understand, asking them to ask questions freely, stuff like that, to ensure that they understand what's kind of going on. We're also hoping to create a short video about the generic offer of diversion to kind of help with this, and that will be shared up too. Understanding the impact of non-admission of guilt. So given a no comment interview, as we've spoken about today, I think Matt and Sandra mentioned it, it can bar children from accessing some diversion schemes that require an admission of guilt. And, many professionals talked about, Black children being less likely to admit an offence or more likely to give no comment interviews, citing reasons such as limited legal advice, and also mistrust in the criminal justice system. So simply kind of being aware that, it can bar children. So obviously we know that it's a legal right to say no comment, but also just being aware of the implications of this, and where possible, just knowing that the options are available to the child. And also being aware of eligibility criteria is another thing as well. So though some diversion schemes do restrict if a child has multiple offences, just kind of being aware that it's not always a barrier, and a lot of areas do, focus on assessing the child and the context behind the offending behaviour before, considering those kind of factors, just being aware. And lastly, diversion can still be an option at court. And we've got a quote from a solicitor. We've had some areas being told that if a case gets to court, diversion is no longer an option, but this is not consistent with areas that are rolling back cases. So just being aware of that and kind of speaking up at that at court. And that's all from me. Thank you.
Thank you so much, Bami. I think we're going to finish in about 3 minutes, just to allow you a question, as we don't want to cut you short. There is one question. You mentioned a lack of child-friendly legal advice. Have you come across any current good child-friendly materials or good practice that lawyers can use representing children? And then, perhaps we can share them with participants.
Is this for me? Sorry.
Yes.
Sorry about that. Do you know what? Actually, the guides that the Youth Justice Legal Centre actually created is really, really helpful, I think, for solicitors. But I think, there's a lot of material out there in terms of how to speak to children in developmentally friendly ways. So looking at stuff from like speech and language therapists. We're not expecting you to have like that full-blown kind of knowledge, but just kind of being aware that some of the things that you might expect a child to know at a certain age, even if they're 15, 16, 17, they might not know or understand. So just being aware that just using simple language and also asking if they understand is one of the easiest things that you can do, I think, to start off.
Thank you. We find that, so many children are not afforded the opportunity to have an out-of-court disposal when they should be. So you know, your research and work in this area is invaluable. Thank you very much for joining us today. And if there are any materials you come across that we can circulate afterwards, then just forward them to Katia or Bianca, and we can circulate them. Thank you. So that brings us to the end of another great session. We truly hope that we've learned tonight we truly hope that what you've learned tonight will be woven into your practice. So please join us in a fortnight's time where I will consider the impact of race on child criminal exploitation, especially as it relates to county lines and racial implications of remand and sentencing on Black, Brown and racialised children, along with two other members of our advisory board, Gary Green and Danielle Manson from Doughty Street Chambers and Garden Court Chambers. And we will also have Dr. Grace Robinson, expert on county lines. So we look forward to seeing you all then. Thank you.